3, 2, 1. This court also does not find any substance in the contention on behalf of the respondents regarding the constitutional aspect with reference to Article 73 and 162 proviso of the Constitution of India. It is evident that the maintainability of the present matter is to be seen with respect to what is provided in Section 378 of the CRPC. Thus, the exclusive power of the Parliament to legislate with respect to entry 8 of List 1 does not in any way come into picture in the present matter. So far as the proviso to Article 162 is concerned, it is evident from the scheme of the distribution of executive power that the exclusive executive power of the Union is confined to List 1 of Schedule 2. Similarly, the state has exclusive executive power with respect to the state list. It also has exclusive executive power with respect to matters enumerated in the concurrent list, subject to any enactment by Parliament on a subject matter in the concurrent list by which the executive power is expressly conferred upon the Union or its authorities, apart from express executive power conferred upon them by the Constitution, with which aspect we are not concerned. It will thus be seen that the argument based on constitutional aspect would ultimately depend upon the fact as to what executive power has been expressly conferred upon the Union or its authorities by Parliament by Section 378 bracket 1 and bracket 2 of the CRPC. Thus, the constitutional aspect of the argument comes back to and hinges upon the interpretation of Section 378 CRPC. The Union or its authorities cannot claim any power in the present matter apart from what Parliament has conferred upon them by the provisions of the CRPC. If, as has been held above, the central government has been conferred only an additional power apart from the general power possessed in all cases by the state government to file an appeal against an order or acquittal, then there cannot be any question of violation of the constitutional scheme. If the scheme chooses to exercise its executive powers in such matters under the law made by Parliament, even where the central government has chosen not to exercise its right to file an appeal, in case the CRPC itself does not make the exercise of power by the state government dependent upon or subservient to exercise of power by the central government. No such limitation on the exercise of executive power by the state can be read by this court. Thus, the submissions made on the basis of constitutional aspect by learned counsel for the respondents must also fail. The further submission that the investigation has been ordered by the High Court and at any stage of the investigation the state government had no role to play must only be noticed to be rejected for the reason that the substantive right conferred by the CRPC under Section 378 is not governed by or dependent upon the investigation or prosecution itself having been carried out by the state or its agencies. Stop.